Hi guys, welcome to my channel. My name is Divya. This is the first ever video of the series of video that I'm going to make on Indian Evidence Act 1872. I know books have everything, every subject, every topic in detail, but my purpose of making this video and the upcoming videos is to make Evidence Act a little simpler for you guys. So let's begin. Evidence Act has 167 sections altogether, which are divided into several. Before learning about them in detail, let us know what Evidence Act is, or let us know what evidence is. So what is evidence? In layman language, evidence is anything or everything that we see, read, learn, experience and believe that something is true or has really happened. Evidence Act lays down the rules which are helpful for the guidance of courts. Evidence Act 1872 is a procedural law as well as substantive law too. That means it is totally a procedural law but has certain elements of substantive law also. It is procedural law because it lays down procedure as to when, why, and what evidence is to be produced in the court. It is substantive because it affects the rights of the parties. For example, estoppel. Estoppel is one of the vital elements of Evidence Act, and about estoppel we are going to learn in the upcoming videos. Let's begin with Section 1. Section 1 says, Evidence Act 1872 applies to all the judicial proceedings. Now, what is judicial proceeding? Judicial proceedings are the legal proceedings that take place in the court. Now we know Evidence Act applies to judicial proceedings, but where does this act not apply? First, court-martials, which include Army Act, Naval Discipline Act, Air Force Act. Second, affidavits. Yes, heard it right, affidavits. Evidence Act does not apply to affidavits. Reason being, affidavits contain facts which are derived or which are based upon the deponent's personal knowledge and are not taken on oath. So, Evidence Act does not apply to affidavits at all. And third, proceedings before arbitration or arbitrator apply to. As arbitrator has to follow the principles of natural justice. Let's come to Section 3. Section 3 lays down interpretation of certain legal terms. It is an interpretation clause where certain legal terms are there and their expressions are defined. So wherever you find those terms or legal terminology in any of the page or any of the sections of Evidence Act, you have to derive its expression in accordance with Section 3 of the Act. First is court. What is court? According to Section 3 of this Act, court includes judges, magistrates, and all those persons who are authorized to take evidence. According to Honorable Supreme Court, Section 3, the definition of court is not exhaustive. It is inclusive. Therefore, arbitral tribunal is considered as a court, but labor tribunal is not considered as a court. Second, fact. What is fact? Fact is anything or everything that we see, that we hear, that we feel, experience or believe in something, and it is capable of being perceived by senses. Fact also includes the mental condition of a person. Let me explain you with an example. I have heard something or I have seen something is a fact. The other person has said something is a fact. You hold an opinion on a particular subject. That is also a fact. Next is relevant. Which facts are relevant? A fact is said to be relevant if it is connected with the other fact in accordance with the provisions of this Act. And those provisions are from section 6 to section 55 of this act, and about these sections we are going to learn in the upcoming videos in detail. Next is facts in issue. A fact is said to be in issue if one fact is asserted by one party and the same fact is denied by the other party. Let me repeat. A fact which is stated by one party or relied by one party, on the other hand it is disputed by another party, such fact is fact in issue. For example, in a trial of murder in which A has murdered B, or allegations upon A who has murdered B, the fact that A has caused the death of B is a fact in issue, as it is asserted by one party but it is disputed or denied by the other party. Second, A has the intention of causing death of B. This is also a fact in issue, as it is asserted by one party and denied by the other party. Next point is document. What is a document? Document is matter which is expressed or described upon a particular substance, or any act, any fact which is either written or drawn upon something. Any statement, any word or series of words, pictures, diagrams which are made upon a particular substance, either a piece of paper or board or upon any substance, that is considered as a document according to section 3 of this act. Example, writing on a paper, words printed on a paper, map, any inscription on metal plate, it is also a document. The next point is evidence. Very important, guys. According to section 3, evidence is defined into two categories, or in the other words we can say evidence is of two types: oral evidence and documentary evidence. Oral evidence contains the oral statements of the witness which are made in the court of law, or those statements which the court requires a person to state in the court. That means all the oral statements. Guys, statement is different from oral evidence, as statements, only bare statements, are simply told by a person in the court, but those are not evidence unless those statements are made upon oath, cross-examined by the other party. Therefore, any statement which is made in the court, in order to make it an oral evidence, it is essential that those statements are made upon oath and those are cross-examined by the other party. Second is documentary evidence. Documentary evidence includes all the documents, including electronic records, which are produced in the court for its inspection. Another important thing, affidavit, as we all have discussed, is not an evidence, but yes, affidavit can be considered as an evidence provided court requires certain facts to be produced or to be proved in the form of affidavit. Then FIR or first information report is not an evidence, it is just the previous statement of the person. Panchnama is not an evidence. Confession of co-accused is not an evidence. Alright, let's move on to the other point, that is proved. What facts are said to be proved? If the court believes that a certain fact exists, then it is said to be proved. That means those facts are said to be proved on which the court believes upon their existence. Example, let me explain you with an example. If the court believes that when the murder happened, when the murder happened in the house, there was a complete darkness outside. So, the incident happened at night is a proved fact. Next point, is disproved. When the court believes or the court does not believe in the existence of a particular fact, such fact is regarded as or termed as fact disproved. That means court believes a fact that it does not exist. So in that case, that fact is disproved. Which facts are not proved? Those facts which are neither proved nor disproved, those facts are not proved at all. Then section 4. What section 4 of the Act says? May presume. Wherever you guys find this word may presume, just keep this in mind. May, M-A-Y, may means discretionary power. It reflects a discretionary power. So may presume means court has a discretion to presume a fact to be proved unless it is disproved, or court can call for its proof. Let me put it in simpler way. Court has a discretion in the situation of may presume. Court has the discretion to presume the fact to be proved or may call for the parties to it to prove it. If the court presumes that the fact is proved, then it is termed as proved unless the other party gives certain evidence in order to disprove it. Then shall presume. Wherever the word shall is there, it means the court has to presume upon the existence of a particular fact unless and until, of course, it is disproved by the other party. Then last but not the least, conclusive proof. What do we mean by conclusive proof? When two facts are declared by the court to be of conclusive proof, then in that case, if one fact is proved, then the other fact automatically gets proved because those were the conclusive proof of the facts. This conclusive proof is very well explained in section 112 of this Act, which we are going to discuss in the upcoming videos. So that's it, guys. I hope you have liked my video, and I'll keep on making such kind of videos so that Evidence Act might sound a little easier for you to understand. If you have liked my video, then please don't forget to subscribe my channel and also hit the bell icon. Okay, thanks a lot for watching this. Bye bye. See you soon.